Article 146, Officers and Servants and the Expenses of the Supreme Court. Clause 1, Appointments of officers and servants of the Supreme Court shall be made by the Chief Justice of India or such other judgment or officer of the court as he may direct. Provide that the President may by law require that, in such cases as may be specified in the rule, no person not already attached to the court shall be appointed to any office connected with the court, such after consultation with the Union Public Service Commission. Clause 2. Subject to the provision of any law made by Parliament, the condition of service of officers and servants of the Supreme Court shall be such as may be prescribed by rules made by the Chief Justice of India or by some other judge or officer of the court authorized by the Chief Justice of India to make rules for the purpose, provided that the rules made under this clause shall, so far as they relate to salaries, allowances, leave, or pensions, require the approval of the President. Clause 3. Administrative expenses of the Supreme Court, including all salaries, allowances, and pensions payable to or in respect of the officers and servants of the court, shall be charged upon the Consolidated Fund of India, and any fees or other monies taken by the court shall form part of that fund. Article 147, Interpretation. In this chapter and chapter 5 of part 6, references to any substantial question of law as to the interpretation of this constitution shall be construed as including reference to any substantial question of law as to the interpretation of the Government of India Act 1935, including any enactment, amendment, or supplementing that act, or of any order in council of order made thereunder or of the Indian Independence Act 1947, or of any order made thereunder. Chapter 5, Comptroller and Auditor General of India. Article 148, Comptroller and Auditor General of India. Clause 1. There shall be a Comptroller and Auditor General of India who shall be appointed by the President by warrant under his hand and seal, and shall only be removed from office in like manner and on the like grounds as a judge of Supreme Court. Clause 2. Every person appointed to be the Comptroller and Auditor General of India shall, before he enters upon his office, make and subscribe before the President or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. Clause 3. The salary and other conditions of service of the Comptroller and Auditor General shall be such as may be determined by the Parliament by law, and until they are so determined shall be as specified in the second schedule, provided that neither the salary of a Comptroller and Auditor General nor his rights in respect of leave of absence, pensions, or age of retirement shall be varied to his disadvantage after his appointment. Clause 4. The Comptroller and Auditor General shall not be eligible for further office either under the Government of India or under the government of any state after he has ceased to hold his office. Clause 5. Subject to the provisions of this Constitution and of any law made by the Parliament, the condition of service of person serving in the Indian Audit and Accounts Department and the administrative powers of the Comptroller and Auditor General shall be such as may be prescribed by rules made by the President after consultation with the Comptroller and Auditor General. Clause 6. The administrative expenses of the office of the Comptroller and Auditor General, including all salaries, allowances, and pensions payable to or in respect of persons serving in that office, shall be charged upon the Consolidated Fund of India. Article 149, Duties and Powers of the Comptroller and Auditor General. The Comptroller and Auditor General shall perform such duties and exercise such powers in relation to the accounts of the Union and of the states and of any other authority or body as may be prescribed by or under any law made by Parliament, and until provision in that behalf is so made, shall perform such duties and exercise such powers in relation to the accounts of the Union and of the states as were conferred on or accessible by the Auditor General of India immediately before the commencement of this constitution in relation to the accounts of the Dominion of India and of the provinces respectively. Article 150, form of accounts of the Union and of the states. The accounts of the Union and of the states shall be kept in such form as the President may, on the advice of the Comptroller and Auditor General of India, prescribe. Article 151, audit reports. Clause 1. The reports of the Comptroller and Auditor General of India relating to the accounts of the Union shall be submitted to the President, who shall cause them to be laid before each House of Parliament. Clause 2. The reports of the Comptroller and Auditor General of India relating to the accounts of a state shall be submitted to the government of the state, who shall cause them to be laid before the legislature of the state. Part 6, the states. Chapter 1, general. Article 152, definition. In this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. Chapter 2, the executive, the governor. Article 153, governors of states. There shall be governor for each state, provided that nothing in this article shall prevent the appointment of the same person as governor for two or more states. Article 154, executive power of state. Clause 1, the executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with this constitution. Clause 2. Nothing in this article shall, subclause A, be deemed to transfer to the governor any functions conferred by any existing law on any other authority, or, subclause B, prevent parliament or the legislature of the state from conferring by law functions on way authority subordinate to the governor. Article 155, appointment of governor. The governor of a state shall be appointed by the president of warrant under his hand and seal. Article 156, term of office governor. Clause 1, the governor shall hold office during the pleasure of the president. Clause 2, the governor may, by writing under his hand addressed to the president, resign his office. Clause 3, subject to the foregiving provisions of this article, a governor shall hold office for a term of 5 years from the date on which he enters upon his office, provided that a governor shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. Article 157, qualification for appointment as governor. No person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 35 years. Article 158, conditions of governor's office. Clause 1, the governor shall not be a member of either house of parliament or of a house of the legislature of any state specified in the first schedule, and if a member of either house of parliament or of a house of the legislature of any such state be appointed governor, he shall be deemed to have vacated his seat in that house on the date on which he enters upon his office as governor. Clause 2, the governor shall not hold any other office of profit. Clause 3, the governor shall be entitled without payment of rent to the use of his official residence, and shall be also entitled to such emoluments, allowances and privileges as may be determined by parliament by law, and until provisions in that behalf is so made, such emoluments, allowances and privileges as are specified in the second schedule. Clause 3A, where the same person is appointed as governor of two or more states, the emoluments and allowances payable to the governor shall be allocated among the states in such proportion as the president may by order determine. Clause 4, the emoluments and allowances of the governor shall not be diminished during his term of office. Article 159, oath or affirmation by the governor. Every governor and every person discharging the functions of the governor shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of the High Court exercising jurisdiction in relation to the state, or in his absence the senior most judge of that court available an oath or affirmation in the following form, that is to say that I, A, B, do swear in the name of God that I will faithfully execute the solemnly affirm office of governor or discharge the functions of the governor of name of the state, and will to the best of my ability preserve, protect and defend the constitution and the law, and that I will devote myself to the service and well-being of the people. Name of the state. After that you have to write the name of the states where the governor has selected for that state. Article 160, discharge of the functions of the governor in certain contingencies. The president may make such provisions as he thinks fit for the discharge of the functions of the governor of a state in any contingencies not provided for in this chapter. Article 161, power of governor to grant pardons etc and to suspend, remit or commute sentences in certain cases. The governor of a state shall have the power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offense against any law relating to a matter to which the executive power of the state extend. Article 162, extent of executive power of state. Subject to the provisions of this constitution, the executive power of a state shall extend to the matters with respect to which the legislature of the state has power to make laws, provided that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. Council of Ministers. Article 163. Council of Ministers to aid and advise governor. Clause 1. There shall be a Council of Ministers with the Chief Minister at the aid head to aid and advise the governor in the exercise of his functions, except in so far as he is by or under this constitution requires to exercise his functions or any of them in his discretion. Clause 2. If any question arises, whether any matter is or is not a matter as respect which the governor is by or under this constitution required to act in his discretion, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion. Clause 3. The question whether any and if so what advice was tendered by ministers to the governor shall not be inquired into in any court. Article 164. Other provisions as to ministers. Clause 1. The chief minister shall be appointed by the governor and the other ministers shall be appointed by the governor on the advice of the chief minister, and the minister shall hold office during the pleasure of the governor, provided that in the state of Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha there shall be minister in charge of tribal welfare who may in addition be in charge of the welfare of scheduled caste and backward classes or any other work. Clause 1a. The total number of ministers, including the chief minister in the council of ministers in a state, shall not exceed 15% of the total number of members of the legislative assembly of that state, provided that the number of ministers, including the chief minister in a state, shall not be less than 12. Provided further that where the total number of ministers, including the chief minister in the council of ministers in any state at the commencement of the constitution, 91st Amendment Act 2003 exceeds the said 15% or the number specified in the first proviso as the case may be, then the total number of ministers in that state shall be brought in conformity with the provisions of this clause within 6 months from such date as the president may by public notification appoint. Clause 1b. A member of the Legislative Assembly of a state or either house of the legislature of a state having legislative council belonging to any political party who is disqualified for being a member of that house under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1 for duration of period commencing from the date of his disqualification till the date on which the term of his office as such member would expire, or where he contest any election to the legislative assembly of a state or either house of the legislature of a state having legislative council as the case may be, before the expiry of such period till the date on which he is declared elected, whichever is earlier. Clause 2. The Council of Ministers shall be collectively responsible to the Legislative Assembly of the state. Clause 3. Before a minister enters upon his office, the governor shall administer to him the oaths of office and of secrecy according to the forms set out for the purpose in the third schedule. Clause 4. A minister who for any period of 6 consecutive months is not a member of the legislature of the state shall at the expiration of that period cease to be a minister. Clause 5. The salaries and allowances of ministers shall be such as the legislature of the state may from time to time by law determine, and until the legislature of the state so determines shall be as specified in the second schedule. The Advocate General for the state. Article 165. Advocate General for the state. Clause 1. The governor of each state shall appoint a person who is qualified to be appointed a judge of a high court to be advocate general for the state. Clause 2. It shall be the duty of Advocate General to give advice to the government of the state upon such legal matters and to perform such other duties of a legal character as may from time to time be referred or assigned to him by the governor, and to discharge the functions conferred on him by or under his constitution or any under law for the time being in force. Clause 3. The Advocate General shall hold office during the pleasure of the governor and shall receive such remuneration as the governor may determine. Conduct of government business. Article 166. Conduct of business of the government of a state. Clause 1. All executive action of the government of a state shall be expressed to be taken in the name of the governor. Clause 2. Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in rules to be made by the governor, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the governor. Clause 3. The governor shall make rules for the more convenient transaction of the business of the government of the state and for the allocation among ministers of the said business in so far as it is not business with respect to which the governor is by or under this constitution required to act in his discretion.